My name is Hassan. Today my question of presentation is critical comparison of career duties and immunities under the Hague Visby rules, Hamburg rules and Rotterdam rules. So I start my presentation of application of rules. The Hague Visby rules apply to a bill of lading or similar document of title, and it do not apply to any negotiable documents. But on the other hand, the Hamburg rules apply to any contract of carriage by sea against freight payment, except as charter parties. The Hague Visby rules apply only where a bill of lading or comparable documents covers the contract of carriage by water. However, in the case of Perrine, it can be seen that the Hague Visby rules will still apply if it is simply anticipated, so that a bill of lading will be granted in the future if it is not issued when the contract is made. However, when compared to the when it compared to the Hamburg rule, it can be observed that the rule only applied to a contract of carriage and not to documents such as a bill of lading. The Hamburg rules apply whether the goods are loaded or discharged. The Hamburg rules apply whether the goods are loaded or discharged. But on the other hand, the Hague Visby rules are limited. The Hague Visby rules are limited to loading. Only export trips from contractual states, ports, or bills issued in a contracting state are subject to Hague Visby rules. The parties can apply both inward and outbound voyage under the now I come to the types of cargo. The Hague Visby rules are applicable to all kinds of cargo, excluding live animal and deck. When it comes to deck cargo, the Hague Visby rule does not apply, but it should be clearly noted in the bill of lading that lading of mere liability on the carrier does not indicate that the cargo is exempt from the rules. As in the case of maritime agency, the bill in this case granted the carrier the right to store the cargo on the deck. When the cargo was lost, the carrier attempted to absolve himself of duty, but it was determined that on the bill of lading it was just the carrier liability to display the goods on the deck. However, because the products did not have to be transported on deck, the carrier was found accountable. When the carrier was found accountable in the scenario of live animal, the carrier is allowed to negotiate. The carrier was allowed to negotiate with the shipper. So the Hamburg rules cover all sort of cargo, including live animal. In the case of deck, the shipper cannot ship the dangerous goods without the consent of carrier. If shipped without knowledge, the shipper will be liable for the damaged goods. The shipper is obliged to provide knowledge to the carrier about the dangerous goods, and it must be mentioned. And the special point is it must be mentioned on the cargo and the bill of the landing. Not only mentioned in the cargo, but even mentioned in the bill of landing. Under the Hague Visby rules on the dangerous goods, with the approval of the carrier's other duty is to issue shopping document. This is also an obligation to the carrier. The main difference between the two rules is that under the Hamburg rules, these documents are much more detailed than the documents will be applicable. Now it comes to period of coverage. The carrier shall be responsible throughout the entire period during which the carrier is in charge of the goods at the port of landing. During the carriage at the port of the discharge, the means that the carrier responsibility is to cover the full period of the carriage under the Hamburg rules. However, it is narrowed under the Hague Visby rules, which do not cover the full period of the carriage. So now, and the next point is the obligation of the The obligation of carrier. The carrier responsibility is to contract ship seaworthy. The carrier is responsible for ensuring that the ship is seaworthy before and during the voyage. The carrier will be held accountable for failing to perform due diligence when a loss or damage occurs as a result of a ship unseaworthiness. The carrier must demonstrate that he used responsible diligence is a personal responsibility of the carrier that cannot be delegated. And the next point is it comes to immunities to carrier. So within the under the Hague Visby rules, within the Hague Visby rules, there are a lot of exemptions available to carrier to exclude their liability. Like he can escape through negligence, as seen in the authority shipping, where the court ruled that the carrier will be held accountable because it is the carrier responsibility to ensure that the carrier responsibility the sea is seaworthy, not due negligence is choosing carrier. If we compare with the Hamburg rules, there are only three exemptions. Available. Following are the categories which provide a carrier under the Hamburg rules. Live animals. The first point is live animal under Article 5, subsection 5, where live animals are transported. Where lived animals are transported, the carrier is not liable if he can demonstrate that he followed loss or damage was caused by special hazard inherent in the type of in the type of good transported. And the other exemption is fire. Under Article 5 subsection 4a, if a carrier is accountable, the claimant must provide that the fire was caused by carrier fault or negligence, his servants or even agents. The carrier can escape liability if he is liable to demonstrate that he is subordinate or agent took all responsible precautions to provide the occurrence and consequences. And the last exemption is deviation. According to Article 5 subsection 6 of the Hamburg rule, the carrier is not accountable exempt in general average where loss, damage or delay in a delivery came. The Hamburg rules, so that's why the Hamburg rules are more restrictive to carrier than the Hague Visby rules. Are mentioned extensive list of immunities to carrier. Now I tell you the time period to bring up the claim. Time bar under the Hamburg rule is 2 years to bring a claim relating to the carriage of goods, rather than 1 year under the Hague Visby rules. Hamburg rules time bar apply both to claim against and by the carrier. And the next point is it comes to the third party. Protection granted to third parties under the Hague Visby and the Hamburg rules will be granted under the condition that the bill of lading is issued and endorsed to a third party. Now I tell you notification of loss of damage. According to Hague Visby rules, the notice of loss or damage must be submitted in writing to the carrier or his agent at the port of discharge before at the time of delivery, or within 3 days after delivery if the loss or damage is latent. Failure to provide such notice is prima facie proof. Prima facie proof is a prima facie proof of a non-compliance with the bill of lading. On the other hand, the Hamburg rules provide that a notice of loss or damage must be submitted in writing by the carrier no later than 1 working day after the goods were delivered to the consignors, and the 15 consecutive days if the loss or damage is latent under Article 19. Failure to provide such as a notice is a prima facie evidence of a delivery in compliance with the transport of the document. And now I will tell you the jurisdiction. The Hamburg rules made a specific provision for jurisdiction. However, the Hague Visby rules do not contain any specific jurisdiction. Now let me conclude my presentation. Finally, the Hamburg rules improved on the Hague Visby rules in various ways. They established greater homogeneity in goods carried by sea than the Hague Visby standards. As stated above, many issues or confusion were resolved through the Hamburg rules. Furthermore, the court occasionally struggled to interpret the Hague Visby rules. Many trading countries, on the other hand, did not ratify the Hamburg rules. Even while the Hamburg rules achieved some improvement, they also introduced several structural issues. So that's why within the interest then the Hague Visby rules.